Again, welcome back to day 2 of the conference. We're thrilled that you're all coming back to join us. We have a great panel to kick off the morning with. This morning, we'll be looking at musical compositions, trying to determine the scope of those compositions, both as a matter of thinking about how they're registered with the Copyright Office and then how it gets litigated afterwards. And then at noon today, we have our keynote address with Rosanne. We're very excited about that. You can view it, I believe, through here, but also through our YouTube channel. So for people who have not registered for the conference, if you know anyone, participants who are with us now, if you have other people who want to view Rosanne Cash's keynote, they can go to the CPIP, literally the CPIP on YouTube, and you can find it live streamed there. And then in the afternoon, we look at the new role of record labels and platforms. Okay, so let's get into this panel this morning. We have a great list of folks who are joining us. We have Professor Robert Brauneis at George Washington University Law School, who's been doing music law and copyright law more broadly for just a long time. He's a very great expert on it. And in particular, some of his recent work has been looking at historical things going on, especially with minority disadvantaged artists and some of the things going on with so-called kind of race recordings and things from the earlier 20th century, and how that set up some kind of bad patterns that really disadvantaged a lot of these artists through the mid and into the later 20th century. And we're still trying to clean up a lot of that now. So he will lead us off with that. We also have Richard Busch, who is a preeminent litigator across many areas of IP, but we love him most here for the music stuff that he's been doing. You probably know him from his role in the Bridgeport case and then in the Blurred Lines case. He's been involved in a number of cases continuing on now, and really at the heart of this question of what is the scope of a composition. Then we'll have Robert Clarida, who's at the law firm of Reitler, Kailas, and Rosenblatt. He's a partner there, and also just has a very long and distinguished career in music litigation, and in fact has degrees in music, so he's bona fide in this. He's a real musician as well as then a music lawyer. And then the same goes for Joe Fishman, who is at Vanderbilt Law School now, and again has just been really just quickly become a preeminent music law scholar, and as well has advanced degrees in musicology. So I think we just have a great panel, and we're going to cover a lot of different angles. Before I turn it over to Robert Brauneis to get us going, I want to just frame what we're doing here. So first, for those who are not as attuned to music law issues, when we say the composition right, we mean the song as written, not as recorded. So the easiest way perhaps to think about it is the way in which very few songwriters operate anymore, but think back to classical composers, Beethoven or Gershwin, and you always have this image of them, you know, with a pencil and paper, and they're writing on the sheet music as they're sitting at the piano, and they are writing out the composition. And so you look at that symphonic score, and that's the composition. Now it's important to think about that and distinguish that from any particular performance or recording of that composition. So when there's a performance, or in particular a recording of someone performing that composition, then that is the sound recording right that we discussed a bit yesterday. Okay, sound recording right just about a particular performance as it's captured in some audio recording technology. But this morning we want to look at the composition itself. Now there's a lot of different ways in which people compose today, some not even writing it down at all, just going directly into the studio, and that's created some of the issues that we'll be looking at this morning. So we're thinking about the scope of composition then. We also have to think about a change that happened in the mid to later 20th century, especially in pop music, where we went from thinking about popular music copyright as about that lead melodic line, the tune you might whistle or hum coming out of a Broadway musical, or you go into the theater and you watch a musical on screen. That sort of top line, it's what everyone sings, it's the main vocals. And for a long time, that was informally at least seen as that was really what music copyright was all about. However, as you got into a lot of more interesting pop compositions, even in the rock space, other space like that, where guitar hooks became very preeminent in a lot of the 60s classic rock and 70s classic rock, keyboard lines, saxophone lines. There were a lot of other melodic parts that really became quite important, and even harmonic parts and even rhythmic parts. And so there was no reason why those couldn't be protected. And so that's a lot of what you've been seeing over the past number of years, is looking at, okay, there was no, or arguably no, copying of that main melodic vocal line, but there may have been copies of other parts of the song. And then the question became, are those parts of the composition? And a lot of that will turn on how we determine the scope of composition as a legal matter and how things were registered with the Copyright Office. So I won't give away the whole game because our panel is going to go much more into that than I will right now, but I just wanted to frame it so you know where we're starting from. Okay, so we're going to start in the early 20th century with Professor Brauneis, talking about some old mirror recordings and some of the issues. Bob, I'll turn it over to you.
Sean, thank you very much, and thanks for the invitation to participate in this, and I look forward to this conversation. So I guess I do want to get to the mirror recordings, but I want to start by sort of leading us to understand what the difference is between the 1909 Act framework and the 76 Act framework, a little bit about how I think that the Skidmore Court got things right and wrong, and then work my way into what I think the 76 Act framework is all about, and maybe some of the troublesome aspects of it because of the history of the 76 Act. So under the 1909 Act, you know, the Skidmore Court, the court that's deciding the Stairway to Heaven case, I think it's absolutely right about the scope of copyright in musical works under the 1909 Act, namely that under the 1909 Act, musical works must be fixed in visible notation, right? And that ties in very much with Sean's, you know, recitation of the traditional classical music composer notating something before, in advance of, separate from anybody performing that work. So far, so good. What I think the Skidmore Court got wrong and didn't really consider is the potential retroactive working of the 76 Act. I think it failed to consider whether the 76 Act provision, which is that musical works can be fixed solely in sound recordings or solely in phonorecords, right? That may well be retroactive, right? And that would do two things, right? First, it would make many musical works that were fixed only in phonorecords before 1978 subject to copyright protection. And second, would make many of those works thicker, since not only the notated lead sheets, which were quite thin, would be subject to copyright protection, but various elements of the broader musical arrangement fixed in the phonorecord would also be subject to copyright protection. So the Copyright Office, I think, has consistently taken the position that the 76 Act is retroactive. Back in 1984, the Compendium 2 of Copyright Office Practices says, guess what? On January 1st, 1978, phonorecords became acceptable deposits for registering claims to copyright music recorded on them. And here's the crucial sentence in Compendium 2. Moreover, music embodied only in phonorecords before 1978 is now acceptable for registration in that form. You can go ahead and reach back and look, you know, register music that was only fixed in phonorecords before 1978 once the 76 Act becomes effective. And that's exactly what happened in the facts that underlie the Abco case, Abco versus Lavine, which the Skidmore Court cites a number of times, right? What happens, those concern copyright protections for songs recorded by Robert Johnson, the famous 1930s blues guitarist. As far as we know, those were never fixed in notated visible form. Rather, they were fixed only in phonorecords of him performing those songs. And on behalf of Johnson, Johnson's sister, that is, Johnson himself, rather famously, was murdered back in the late 1930s. So LeVere registers copyright in 24 of those songs in 1991. What are the deposits he submits with those applications? They are the sound recordings made back in the 1930s of Robert Johnson performing those songs. The Copyright Office accepts those deposits, registers the works. And the issue addressed by the Ninth Circuit in APCO is only whether the distribution of the phonorecords published the songs, right? Particularly in light of a 1997 statute which said that the distribution of phonorecords before 78 is not going to publish any musical works that are fixed in the phonorecords. But no one in APCO is contesting that the phonorecords recorded back in the 1930s did in fact fix musical works that were not notated, okay? So, so I start with the perspective that there was this 1909 Act regime that required visual notation, but the 76 Act came along and the Copyright Office and APCO perfectly accept the possibility that it's retroactive and that works fixed in phonorecords, even before 78, are protected. Now, of course, if you don't register them, right, that has a couple of impacts under both Section 411 and Section 412, right? Section 411 says you can't go into court and litigate without having registered. You can still, doesn't mean that you're limited to infringement that occurs after registration, but you do have to go back and register those thicker works maybe before you can litigate them. And 412 says you can't get attorney's fees and statutory damages for works that were for infringement that started before you registered. So you may be limited in your remedies if you haven't registered those works until later. But that certainly leaves open the question of the scope of a musical work that is fixed in a sound recording, right? And in particular, we have to ask the question, are there elements of the sound recording that we can identify as composition elements, which are properly part of musical works, and other elements that are merely performance elements? They're only part of the sound recording. And under Section 114B, which limits the scope of protection in sound recordings, can be freely imitated as long as the fixation is independent. So I've taken this position in an article I wrote some time ago in favor of a kind of broad definition of what belongs to the musical work. And I think it's not just a melody that can be abstracted from the sound recording, but essentially everything that we experience as music, the harmony, the rhythm, the timbre, and so forth. And if I were pressed to say why, very briefly, because I only have a brief time here, I would say, because that's how we actually experience music holistically. And how we experience music is connected to why musical works are valuable and whether one musical work has copied enough from another to usurp its market, right? Something we're worried about in copyright law. However, a broad definition of musical work doesn't necessarily need to lead to some very broad infringement liability. And I think that's quite the opposite. Back in 2011, Jamie Lund showed that if you put the same melody in two very different contexts, musical contexts, with different harmonies and rhythms that were typical of different genres, people wouldn't necessarily recognize them as the same melody, right? So that could actually shrink the scope of copyright protection if from the idea of protecting melody in the abstract, if it turns out that melodies in context are not recognized as being similar. And similarly, the fact that a performance, what we might think of as a performance element, like bending a note on a guitar, the fact that that could be considered as part of a musical work, part of the composition, does not mean that copyright in that particular musical work that involved a bent note on a guitar, the scope of that copyright extends to cover every instance in which a note is ever bent, right? Absolutely not, right? Any more than a work that has some Yoda-like dialogue in which we put the verb before the subject means that the author of that work has copyright that extends to anyone ever putting a verb before a subject in a sentence, right? We have the idea expression doctrine to take care of that kind of overclaiming or overreaching of copyright. So let me say one more thing about section B, the limitation of scope of copyright in sound recordings, as Sean averted to. That rule was born in a case called Supreme Records versus Decca Records. And that involved the question of whether what African-American arrangers and recording artists added in the course of making the first recording of a song could be freely copied by a record company that wanted to make a cover recording featuring a white lead singer and white backup singers. And what they copied in the Supreme Records case was not just vocal style, it was 4 bars of a vocal production, it was new words and music for backup singers who were involved in a call and response with the lead singer that was not in the notated song. And the Court of Supreme Records said, no, none of that's protected. And it said that at a time in which everybody knew that the effect was going to be that white recording artists catering to the white popular music market would get to take a lot of music from African Americans who were limited to making race records for the smaller African American market. And that's what happened, right? For at least 15 years afterwards, there was a huge, you could count hundreds of white covers of African American originals in which the white covers did not credit the African Americans for what they had contributed. They certainly didn't ask their permission, and the original musicians got no compensation for what they created. So I think that history, which I've written about in a paper that's up on SSRN, should give us some pause in embracing that 104B limitation and settling on a very narrow definition of the musical work. And that's what I got to say for now. Thanks.
Great. Thanks, Bob. Just fantastic stuff. And I, again, applaud all the work you're doing and look forward to seeing more of it as you get more of it on SSRN and published out there. Now let's turn over to Richard Busch, who will bring us up to the present date in which we're actually litigating this stuff. As I said, he's on the forefront leading litigation in many of these cases. Richard, take it away.
Thank you, Sean, and thank you for having me. A couple of things or comments I'd like to make about what I just heard, both from Bob and from you. I somewhat disagree with the manner in which you set up this program by saying that we're talking about the musical composition as distinguished from the recording. Yes, there's 2 separate copyrights, the sound recording copyright and the musical composition copyright, obviously. But as you also mentioned, Sean, modern music is created in the studio. So to go back to what I'm most well known for these days, the Blurred Lines case, we can talk about the fact that Marvin Gaye created Got to Give It Up in the studio. He did not sit down and write out notation. So there is no written notation that served as the basis for Got to Give It Up. It was the recorded composition. So when I'm litigating my cases, I always refer to the quote unquote recorded composition, because that's the way I think it is most aptly described. So yes, there is a difference between a sound recording copyright where someone actually lifts the actual sounds from a sound recording, which would give rise to a sound recording infringement case, versus the copying of what I call the recorded composition, which are the compositional elements that are found in the sound recording. So I've made the argument, and I've made this successfully in the past. One of the cases I litigated a few years ago was a case by the name of Bridgeport Music versus A&M Records, where there was the copying of the Bow Wow Wow Yippee Yo Yippee Yay from Atomic Dog, as well as the use of the word dog in the same compositional placement in the infringing song as in Atomic Dog. And we also alleged rhythmic panting, believe it or not, as part of the infringement claim. And the defendant raised the issue that those elements were not found in the deposited lead sheet, at least the rhythmic panting was not. They, of course, alleged that dog and the bow wow yibio was not original, but focusing on the rhythmic panting for a second, they said that was not part of the composition. It was, in fact, not in the lead sheet and therefore could not serve as our compositional claim. And we responded in an argument that was successful, that when the writers of Atomic Dog created Atomic Dog, they did so in the studio, and therefore the composition and the recording are one and the same. In other words, the composition is found within the recording. So therefore, they are synonymous. They are the same, and so therefore you cannot, say it's not part of the composition. And that was a successful argument that we made. Now, of course, so that kind of leads to the question that was discussed by Bob a moment ago and kind of set up by you a little bit, which is, what is the composition? What are the protectable elements of the composition? Is it melody? Is it more than that? And so I think a good place to start for that is the Ninth Circuit discussion in Swirsky, because that kind of answers the question, at least in the Ninth Circuit. And I'll just read from that for those who are not, just a little bit, because I think this addresses the issue directly. The court said in Swirsky, in analyzing musical compositions under the extrinsic test, we have never announced a uniform set of factors to be used. We will do so now. Like software programs and art objects, compositions are not capable of ready classification into only 5 or 6 constituent elements. Music is comprised of a large array of elements, some combination of which is protectable by copyright. They talk about the Three Boys case and that they sustained a copyright infringement claim where the copying was of the title hook phrase, including the lyrics, rhythm, and pitch, shifted cadence, instrumental figures, the verse-chorus relationship, and the fade ending. And they went on to say other courts have taken into account additional components of musical compositions, including melody, harmony, rhythm, pitch, tempo, phrasing, structure, chord progression, and lyrics. And then they went on to list even additional elements that make up the composition. So if we start with that framework, that some combination of elements can sustain a copyright infringement case of the composition, and even the unique combination of unprotectable elements can sustain a copyright infringement claim, I think that is a nice way to segue into the blurred lines case, because we're not just talking about melody. And in fact, in the blurred lines case, Judith Fennell identified 15 different compositional elements that she said were copied in blurred lines. And it's not just the melody, it's all these things, timbre, structure, all these things that the Ninth Circuit identified in Swirsky as being part of the musical composition. So in blurred lines, the argument of the defense was that this was just the copying of an era. This was the evocation of an era or a genre, and there were not compositional elements that were copied. They would say that you could not point to notes that were identical. Now, we showed, I believe, that was not correct, but that was the argument. And so Judith came up with this idea of a constellation of elements that were substantially similar. And that constellation, under the Three Boys case in the Ninth Circuit, was acceptable. It did not make new law, in other words. It was this combination of elements from vocal melody to the keyboards, to the bass line, to one thing that was really interesting that I think had a lot of impact on the jury was that in the blurred lines case, there was a part of Got to Give It Up where Marvin begins speaking in a non-melodic form. And it's more of a, she called it a parlando, which is a precursor kind of to rap. And in blurred lines, T.I. comes in and does a rap section in the song as well. And what she detected was that in Got to Give It Up and Blurred Lines, the parlando and the rap started at the exact same second and ended at the exact same second, at the exact same measure of both songs. And there was what she called word painting that preceded the parlando and preceded the rap and went after the parlando and the rap with words that were very similar. So the argument was that Blurred Lines, that Got to Give It Up, I should say, was the blueprint for Blurred Lines, and that there were all of these elements that were substantially similar in the two songs that made for the infringement claim. And the argument was that it followed the Three Boys case. So obviously we were successful in that argument. It's been controversial. Obviously, there are people on both sides of the equation about whether they agree or disagree with it, but it did not make new law, is my point. Is this the elements that were pointed to in Blurred Lines emanated from both the Three Boys case in the Ninth Circuit and Swirsky, that has a very broad definition of what a musical composition is. Now, these cases are continuing to be litigated. Obviously, we're involved in a lot, both before, for example, I mentioned the Atomic Dog case, Bridgeport Music versus A&M Records, and many others. You know, as you know, Sean, I filed, what's now kind of infamous litigation in another lifetime, the Bridgeport Music litigation, where we sued the entire rap music industry, like 600 songs, and made a lot of law about what can and cannot be copied, and established, at least in one case, that, at least the Sixth Circuit follows it, that in a sound recording case, the digital lifting of a sound recording, even a second or two, is copyright infringement without a de minimis defense. Other courts haven't followed that. But we're continuing to litigate this, and the new, there have been cases following Blurred Lines that I'd just like to talk about for a second. I'm not sure how much time I have, but in the next few minutes, I'd like to talk. And I think this will set up Bob's discussion a little bit. When we litigated Blurred Lines, in every case that we found prior to Blurred Lines under the 1909 Copyright Act, in every case, without exception, for 115 years, the recording was able to be played of both the infringed song and the infringing song to determine whether the two compositions were substantially similar. The issue of whether the composition was limited to the lead sheet as opposed to the recorded composition had never been an issue in cases we found. Now in the Three Boys case, I will say that it was raised, but it was raised on a different issue. It was like on the jurisdiction of the court, because the question was whether the court had jurisdiction to hear it because the lead sheet did not contain the elements, and the Ninth Circuit said they did, and it was not an issue, but it was kind of a related issue in the Three Boys case. But in every case that we found, there was never a question about playing the recorded composition to compare it to the infringing song. In the Blurred Lines case, as everyone on this panel knows, the court, without getting into the details of the why and the analysis of the 1909 Copyright Act, ruled that our claim was limited to this deposited lead sheet, and the 15 compositional elements that Judith had identified were not able to be raised as part of the infringement claim because only about 5 or 6 were arguably reflected in the deposited lead sheet that someone created to get the copyright registration on file after Marvin created the song. So we were not even able to play Marvin Gaye's Got to Give It Up at trial as a result, because the court ruled that to do so would be to prejudice the defendants, because it would expose the jury to elements that the court was ruling were not part of the case. So that was a shocking development, obviously, to us. We still won because we were able to play excerpts of what was arguably within the lead sheet, and that raised a big fight about what is reflected by a lead sheet and what's not. And Judith Bunnell pointed out what she believed was part of the lead sheet, and the other side said it wasn't, and we had a big fight about that. But that's how we were able to at least play some of the music at the case. Now, the Ninth Circuit, interestingly, on appeal, in a footnote, really was skeptical of this lead sheet decision. The three members of our, at least two of the members, because it was a dissenting judge, the two members of our panel were really skeptical of that ruling. As we all know, however, ultimately in the Led Zeppelin Skidmore case, the court followed that decision and ruled that the lead sheet does, at least under the 1909 Act, subject to what Bob said a moment ago about applying the 76 Act retroactively and maybe going out and filing a new lead sheet or the recording itself, because now the Copyright Office does accept the recording as the composition in a deposit copy when they didn't originally. But they did rule that at least for the original copyright filing, the lead sheet under the 1909 Act, not the 1976 Act, does define the scope of the copyright. That was, I think, a wrong ruling. One other thing that I think I would like to mention, and I think, since that time, it's come back. There have been other cases. There's a case involving Ed Sheeran and a Marvin Gaye song. The Gaye family is not part of the case. Ed Townsend, the co-writer, is, where the court in the Second Circuit was waiting for a ruling on, by the Led Zeppelin en banc court to determine how he would define the scope of the compositional claim in that case, the Thinking Out Loud case, pending in the Southern District of New York. He has indicated he's going to follow that decision, but now, as I understand it, the plaintiff in that case is now filing a new deposit copy, maybe the recording itself, maybe a revised lead sheet, I'm not sure which. I know Bob's going to talk about the impact of that in a moment, so I'm not going to steal his thunder. I'll let him discuss that in a moment. But these raise interesting issues. One last point that I want to raise, this really doesn't go to the scope of the copyright, but it's an interesting additional issue that has come up in the Ninth Circuit Led Zeppelin case. I just want to talk about for 30 seconds. The defense really tried to take advantage of the en banc appeal and try to change the rule on musical composition copyright claims by claiming that the court should not follow the substantial similarity analysis that the court has always followed, but should go to a virtual identity analysis. And I'm glad the court rejected that. And the court said that basically virtual identity is only involved in copyright claims where there is lack of creative choices. Like I like to use the example of a painting where you're painting a tomato. There's only so many ways to paint a tomato, so there's a thin copyright there. Whereas for musical composition, there's literally millions of creative choices that can be made. So, it should not be used. And I'll just lastly make note of the fact that there's right now a case involving Taylor Swift, involving one of her songs. The district court had dismissed it on lack of originality because it's based on the lyrics, hate is gonna hate, and player's gonna play. And the Ninth Circuit reversed and said it plausibly did have originality. And when it went back to the district court, the defendant tried to raise the fact that there were, that the virtual identity standard should apply based on the Led Zeppelin case because there were allegedly lack of creative choices, and the district court rejected that and said, no, there's all kinds of creative choices in making, in writing and having musical composition. So he rejected the virtual identity and rejected their attempt to expand the Led Zeppelin Skidmore case on that virtual identity issue, sticking with substantial similarity.
Great, Richard. Thanks so much for this really great setup. And now I want to turn over to Bob Clarida, who's going to dig down on this and an interesting historical footnote about some attempts to clean up this registration issue after the fact, but even from many years ago. Bob Clarida, turning it over to you. Unmute yourself, Bob.
Yeah, thank you very much, Sean. And thank you, Richard, for that great setup, because this leads exactly into what I'm going to be talking about. Could I have my first slide, please?
Richard, you might want to mute your mic too to cut down the background noise if you could.
Yes, sir, I'll do that.
Thank you.
Okay. And my general idea is we talk about substantial similarity, but you have to say compared to what? If any of you remember that great song of Gene McDaniel's, it's as relevant now as it ever was. Next slide, please. The Led Zeppelin holding, as Richard just said, in so many words, it says the deposit copy defines the scope of a copyrighted work for unpublished musical works under the 1909 Act. And it's important to note here what the limitation on this is. unpublished musical works under the 1909 Act. That is, works that were registered in the Copyright Office before there was published sheet music, because under the 1909 Act, of course, you could start your statutory copyright by publishing with notice. This is talking about works that were registered in the Copyright Office with a print sheet music deposit copy, which is all the Copyright Office would accept at that time, prior to the issuance of the sheet music. So that's the holding that we're talking about. So this had this unintended effect that there's a lot of authorship in the sound recording that people hear, that people think of as part of the song, that didn't make it into the deposit copy. Next slide, please. So here are just some deposit copies of some songs that you all may have heard. Stairway to Heaven. Where's that lovely acoustic guitar intro and the recorders and all that? There is not any of that in the deposit copy. If you can see this on your screen, blow it up a little bit. It starts with the vocal melody. There's a lady who's sure all that glitters is gold. That's the start of the song according to the deposit copy. Hotel California, according to the deposit copy, starts on a dark desert highway. Well, of course, there's this huge, elaborate acoustic guitar intro to Hotel California that goes on for a minute or so, I think. A huge part of the song, long before the vocal comes in, no trace of it in the deposit copy. Born to Run, the deposit copy shows that it starts with, in the day we sweated out in the streets. Well, no, it starts, that's how Born to Run starts. That's not in the deposit copy. So I was thinking about this. The Led Zeppelin holding really bothered me. I agree with Richard. I think it's unfortunate. I see the logic behind the court's decision, but I do think it's just perpetuates this legal fiction about what a piece of music is, that none of the world thinks of it that way. And it's only copyright lawyers counting dots on a page that could come up with that. So I came up with a term that I coined in writing a piece about this. Next slide, please. I call it undeposited authorship. And this is all this authorship that we hear in the song when we hear it, that the defendants who are alleged to have copied the song heard when they heard it in the song. But it's not in the deposit copy, so legal fiction, it doesn't exist, it's not part of the composition. The Copyright Office filed an amicus brief, and I don't have a slide of this, I'll just read it to you. The Copyright Office filed an amicus brief in the en banc rehearing of the Led Zeppelin case of Skidmore. And I'll just read you, this is buried in the middle of a paragraph on page 19. This is not something they shined a real bright spotlight on, but it's in there, and they say, and they picked up on this point in their oral argument. The government argued in the en banc oral argument. But this is on page 19 of the Copyright Office brief. It says, thus, in many cases, sufficiently original compositional material captured in sound recording versions, but not published or registered with sheet music before 1978, are currently protected by federal copyright law, although such material must be separately registered. So this is making the point that yes, that copyright in that undeposited authorship is still valid. It persists. You know, it's common law copyright, you know, up until 1978, and it becomes statutory in 1978. But the Copyright Office takes the position, it must be separately registered. So I started thinking, well, how would you do that? I mean, and Richard was talking about in the Ed Sheeran case, now there's been this development that they're trying to revise the deposit copy or put in a new deposit copy or something. We'll see how that plays out. But in fact, this has already been done. And next slide, please. I just sort of stumbled across in my travels this registration from 1988 for Sympathy for the Devil. And here's the printout from the Copyright Office. I didn't actually get the certificate, but here's the printout from the Copyright Office on it. It's a copyright, and it's a PA. Notice the registration number is a PA. This is not a sound recording registration. This is a compositional registration. And if you look down to the authorship on application, about 3/4 of the way down, words, music, and arrangement. Mick Jagger and Keith Richards. Basis of claim, new matter, arrangement, and revised melodic line. So this is not a new registration to supplant the existing deposit copy. The existing deposit copy actually is, they were being totally above board with the Copyright Office here. Previous registration, 1968, EU 75421. So they registered a sheet music deposit copy in 1968 for Sympathy for the Devil. They're doing this one to capture all the authorship that's in the sound recording that wasn't captured by that lead sheet. And you see what the deposit copy is? It says appears in Beggar's Banquet, London record number, sound disc, 33 1/3 RPM stereo, 12-inch, side 1, band 1. That's the deposit copy. They're not claiming the sound recording, although they could actually register the sound recording with that same deposit copy, obviously. But this is claiming new matter, basis of claim, arrangement, and revised melodic line. So you start thinking, well, what does that actually encompass? It probably encompasses, my guess is the guitar solo, which Keith Richards plays, a very famous sort of groundbreaking guitar solo. It says written by Mick Jagger and Keith Richards. So it's only the things, I guess, that Mick Jagger and Keith Richards authored that's captured in the sound recording. So maybe the congas aren't captured, maybe the background vocals, I don't know. Did they write that? Did one of the singers come up with that spontaneously? Did they say, hey, sing some woo-woos over there? Who knows what actually this covers? It's you know, it's not self-explanatory, but it covers a lot of authorship that was not in the original deposit copy. So this is something the Copyright Office is on board with. They have done it as early as 1988. You see, this was registered in 1988. Look down at date of creation, it says 1968. Date of publication, 1978, January 1st, because as the statute tells us, on that date, those works became published. This is, I think, something we're going to start to see a lot more of as these cases percolate through the courts. Even if you don't get statutory damages and attorney's fees, because you do this, you know, sort of after the fact registration to capture all this undeposited authorship, you won't get statutory damages and attorney's fees, but, you know, it's better than nothing. It's better than, you know, not being able to proceed with your case at all. So I think this is going to be a growth industry. I think we're going to start to see a lot more of these things as people realize that the Ninth Circuit holding in Skidmore v. Led Zeppelin could really seriously reduce their chances of prevailing on an infringement claim. And that's all I got to say.
Great, Bob. That was just fantastic and really just a very helpful point too. And I think anyone of the participants who's, you know, actually involved with musicians, composers, you know, this is, if you haven't thought about this technique yet, I'd strongly encourage you to start exploring it if you want to capture, and I like that term, undeposited authorship. It's all that cool stuff. But as Bob also points out, you know, you got to kind of make sure who the people you're listening as authors actually wrote all that stuff. You know, if Mick and Keith didn't know how to play congas and didn't do that stuff, then they might not really be able to be claiming that. So it's going to be interesting. Now let's turn it over to Joe Fishman.
All right, thank you. So I want to turn back to this other issue in the blurred lines case, not the lead sheet issue that Bob Clarida was just talking about, but the question of how do we define the scope of actionable similarity? Once we know what the work contains, how do we define the scope of what would be considered infringing or not? On that issue, I'm also going to begin with the blurred lines case. Because while I don't love the outcome in that case, I do agree with Richard that people talk about it as if it did more doctrinally than it actually did. So I'm beginning with it to downplay it in some sense. Getting past summary judgment, first of all, and then getting the jury verdict, and then getting the court to deny motion for judgment as a matter of law following the jury verdict had very little to do with the top line melody in the case. We've already heard about this, the constellation of different musical elements that Judith Fennell, the Gay Estates expert, had identified, keyboard parts and bass lines and word painting and parlando, et cetera. And there were a lot of people, both in the both lawyers and also people in the musicology space, and also some recording artists that were, I guess I would say they were enraged at this notion that a music infringement case could turn on something other than the top line melody. And for most of copyright history, they would have had a point. Up until the 1990s, thereabouts, courts really did just focus on a series of pitches in a music infringement case. They were proceeding from the premise that a work's tune was what made it valuable. That's what gave it its musical identity. And it's not like US courts were just making that up out of nowhere. Courts in the UK had said that beforehand. And that was really the dominant aesthetic norm in Europe in the 19th century for what made music good. Now, that being said, saying the top line melody is the most important thing is just not going to be an accurate statement when we look at a wide variety of popular musical genres. That was the premise, though. And then beginning in the 1990s, courts started becoming more receptive to infringement claims over selection and arrangement type theories of infringement, where you had combinations of different musical elements that weren't strictly about the tune. And here's where I think Blurred Lines gets unfairly scapegoated, because I don't think it caused a shift away from focusing on melody. I think it continued a shift that was already underway. And if you think about this as a matter of policy, there are going to be trade-offs to that shift. If we are trying to be accurate about what makes a given piece of music creative, then focusing on that top line melody is myopic. That's not how a lot of popular music is created, as Richard said. And as Bob Brauneis said, right, that's not how a lot of music is experienced for listeners either. We experience music holistically. But once we start saying that infringement could be about selection and arrangement of these multiple variables, rather than just that single variable of a sequence of pitches, then the whole infringement analysis gets much more complex and it gets much harder to predict. And I think there are two implications of that. One is a greater reliance on experts. So there was a line in the Ninth Circuit's majority opinion in the Blurred Lines case, where this was the majority responding to the dissent, where the dissent had engaged in a pretty detailed musicological analysis of its own. The majority said, it's unrealistic to expect district courts to possess even a baseline fluency in musicology, much less to conduct an independent musicological analysis at a level as exacting as the one used by the dissent. After all, we require parties to present expert testimony in musical infringement cases for a reason. We require parties to present expert testimony. I think that's a really striking statement. In the Three Boys case that has gotten some discussion here, the Ninth Circuit had said that the test for music infringement often requires expert testimony in music cases. And then 4 years later in the Swirsky case, the court restated that proposition, but it deleted the word often. Experts are just simply required. And then that gets doubled down on in the Blurred Lines case. And that notion that expert testimony is required to assess substantial similarity, that's not the norm across other copyrightable subject matter, right? Music cases are starting to look a lot more like software cases. The second implication is that it's going to be harder to decide cases on summary judgment. When you don't have cases being decided on dispositive motions, a jurisprudence doesn't get to develop as much. More of these cases are going to a jury or settling before they go to a jury. The less guidance the rest of us get as to what kinds of copying are allowed and what kinds of copying aren't. And so for me, the key word to describe how copyright is defining musical compositions today is complexity. I think one of the unfortunate myths of the Blurred Lines case is that it was litigated as a claim over a feel or a groove, or Richard used over an era before. It wasn't. It was litigated as a case over the nitty-gritty. It was a case that was about technical details of the work. And if you read the expert reports, and if you read the trial testimony, they are very much trying to open the hood of the work, so to speak, and see how it works on the inside. There were, just to give an example, there were multiple demonstrative slides at trial devoted to each alleged similarity that featured transcriptions and visual diagrams and timelines that were accurate to the millisecond showing how corresponding audio clips matched up. In one particular sequence, there was less than 1 second of audio that merited 5 separate slides comparing pitch-shifted MIDI synthesizer renderings. Now, I don't want to claim that that is what actually drove the jurors' decision, right? I'm not in their heads, and they could have reached that decision based on a sense of unfairness, based on a sense of inequity. They could have reached that decision based on some pretty awful testimony that Robin Thicke and Pharrell Williams gave that came back to bite them at trial.
Or I'm just incredibly persuasive.
I'm sorry?
Or that I'm just incredibly persuasive.
Yes, the substance mattered not at all. It was entirely the lawyers. That could be as well. Right, so any of these things could have actually been what tipped the scales. But in terms of how the case was presented to the jury, not to mention how it actually got over the summary judgment hump and reached a jury in the first place, this was a case that was in the musical weeds. Finally, I just want to mention one thing to keep an eye on that may be changing. This is something else that Richard has already mentioned. Which is the whether we should be looking for virtual identity versus substantial similarity in musical cases. So in the Skidmore case, the Stairway to Heaven case, there was a footnote. And it was a footnote that had dicta, but I think it is potentially important dicta, saying that where the range of possible expressions is narrow, you get a thinner scope of protection, and you are looking for something that approaches virtual identity. Now that might be the case in Richard's example where you're painting a tomato, but it also might be the case where you have a lawsuit that is based on a short snippet rather than an entire song, right? A short musical phrase. And I think there are some early returns where we're seeing courts draw that kind of distinction between claims over alleged similarities that do pervade an entire song, like the Blurred Lines case, versus those that are alleging similarities just in short snippets. And I think it's those snippet cases that may have a hard time, or a harder time at least, going forward. So this past year, a trial judge in a case involving Katy Perry relied on that footnote from Skidmore to toss out an infringement verdict against Katy Perry. A couple of weeks ago, there was an infringement claim against The Weeknd that was tossed on summary judgment for similar reasons. And so I think if there's one area where judges might be reasserting themselves as gatekeepers, and it's still early to tell, but where this is something I think we should be keeping an eye on, it's going to be these cases involving short fragments of music rather than an entire musical work front to start.
Great. Thanks so much, Joe.
Can I say just 30 seconds of two things that I think
30 seconds, counsel, 30 seconds.
All right, two things. One, I think on that issue of the virtual identity, I'm not sure the Ninth Circuit meant to imply that it can apply in a musical case. And I think that if you start going down that road, the exception could swallow the rule, because you could always come up with anything where you could say, oh, the creative choices were limited. So that's a point that's going to be argued. And then secondly, I think it bears mentioning that in the Blurred Lines case, while Pharrell and Robin Thicke said that neither Marvin Gaye nor Got to Give It Up came into their mind while creating Blurred Lines, Pharrell actually gave an interview where he essentially said that he reverse engineered Got to Give It Up when creating Blurred Lines. So getting into the nitty gritty of it, that appears to be what happened.
Okay, thanks. Panel is just excellent setup for all these different issues. I think our participants get a sense of just the wide range and how this can get quite technical, but then maybe is it helpful that it gets so technical? And so someone on that score, on the technical matter of it, we actually have Judith Fennell has been able to join us. And so we're going to have her ask the first question of the panelists. So Judith, if you are there now, please chime in now.
Hello.
Oh, there you are, Judith. Welcome,
Hi.
welcome. So glad you could join us.
Thank you very much. So I really enjoyed the panel. It was fantastic. Thank you for inviting me. And so I guess my question would be to any panelists, but particularly to Richard. So there was this very big gap between what the lead sheet showed on paper in the blurred lines case and what was on the recording in which Marvin Gaye himself participated. There was a big gap of material, as you heard, between 15 and what became watered down to 8 similarities that were only able to be substantially aided in the lead sheet. So I guess my question is, things that we weren't allowed to include, such as the cowbells, such as the backup singers singing woo on the, that second half of the third beat for 62 times in blurred lines, and many, many other specific similarities that were not included because they didn't show up on the lead sheet. So my real question is, what would have happened if all of those had been included and were nowadays considered part of the scope of the copyright because of the recording elements?
Well, I mean, what would have happened? We won. So,
We would have won more.
We would have
won betterer win.
We would have won more easily. I don't know how to answer that question well, because we did win. So, but I do think and I think the overarching theme of this panel, and I think pretty much everybody's on board on this issue, which is that lawyers and judges sometimes overthink things to the point that is separate from reality. I mean, Got to Give It Up was created by Marvin Gaye. He was the author, and everything that he created was part of the song. And then to say fictionally that some lead sheet that no one's ever heard of, was never meant to be played, was never meant to be heard, becomes the composition is absurd. I mean, it's literally absurd. And by the way, in the case, one of the reasons, I think this is really funny, and it's a good little story to tell, but what my opponent did in that case was to have their expert create a recording of just the lead sheet and then played it for the jury as if that was the composition and compared it to blurred lines. They were laughing. They heard Got to Give It Up before. They knew that bore zero resemblance to what Got to Give It Up was. I called it a Frankenstein monster in my closing argument. And they felt like they were trying to trick them, because it is. It's a sleight of hand. And so you're basically disenfranchising the author of what they created. And so it's a joke. I mean, that's as clear as I can say it. I think it's a joke, and it's detached from reality.
So we only have about a minute left. Let me just take Judith's question a little bit further and meld it with a question from one of our participants, Michael Dawson. And he's now asking, coming out of this, well, so protect my compositions, should I submit a variety of PA copyright registrations, one for lead sheet, one for a full orchestration via something like Sibelius, and another to itemize the so-called constellation? Now, I think that the panelists, we all know that you could say submit a phono recording, but let me just go through maybe everyone quickly, starting with Bob Brauneis. If we submit an audio recording to register the work, as we all can do now, should we put some notation in there, some material saying, if it's a full band recording, whether everything on that truly is attributable to the author, or whether there's still some sideman stuff on there? What do you think about that, Bob Brauneis?
Also, I think there probably is some. I mean, sideman, I think, is a loaded term.
Yeah, that's
I think
not the word.
there is some authorship probably on the recording that is of a musical work authorship that is not attributable to the featured artists, right? And that, I think, actually is a positive thing because it suggests inclusivity in musical work authorship. There's a very, very interesting study that showed that the average number of authors in registered musical works hit recordings went from about 1.8 in the 1960s to 4.03 in the 2000s. Why is that? I mean, my quick sense would be that's because sound recordings are being deposited as the musical work, and they're kind of looking at, okay, here's the guy who laid down the beat, here's the vocalist, you know, here's the lead guitarist, here's the whatever. We're all giving them a part of ownership in the musical work that is embodied in the sound recording, and I think that's a good thing.
Yeah, and I give a lot of love to the sideman. I've been a sideman on people's recordings, and I contributed original guitar parts that the so-called composer had no idea about, and I just kind of gave it to him. I didn't know what happened to it afterwards. Clarida, what do you think about this?
Yeah, no, I think probably far be it from a lawyer to say that's being too cautious to submit 3 deposit copies. I think you can get everything in a sound recording, but copyright registrations are $65, so you might, why not? You don't lose anything. But I think it's important to note that Copyright Office will not grant a second registration for the same work. You'd have to call it an arrangement or a version or something, because if you've got a registration for blurred lines on a lead sheet, you can't get another registration for the composition blurred lines. You have to call it, as the Stones did with Sympathy for the Devil, you have to call it an arrangement. But I think, it's true what you're saying about session musicians and so on, and occasionally artists have just been magnanimous and said, okay, I'll credit you as a writer. I mean, I think there's an anecdote about David Bowie's Young Americans, and the background vocals in that are so fantastically woven into the song. It's really the hook of the song is the background vocal, which was improvised on the spot by Luther Vandross, who was a session musician, and he was credited as a writer of the song. He owns part of the song because Bowie recognized how important that was to the song and did the right thing. I think a lot of session musicians are under work for hire agreements, and anything they create in the session is owned by whoever has the work for hire agreement with them, whether it's the label or the artist or whoever it might be. So the ownership question very often would, I think, be resolved by those contractual arrangements. But not in every case, and I certainly think there's room for a lot of ownership disputes if we start seeing people claiming the entirety of a sound recording when they didn't create every piece of authorship on it.
All right, Joe, why don't we give you the last word? We're a little bit over time, but I want you to chime in on this as well.
Okay, so I agree with much of what the Bobs just said. I'm in favor of an inclusive definition of musical authorship, so long as we're actually being accurate about who authored what. And I think that's a slightly different issue and does not need to conflict with the issue of how expansive we're going to be in defining infringement. Right? We could have a much more real world, capacious definition of what counts as musical creativity that could get you copyright protection or get you joint author status without necessarily saying that we are going to have an equally capacious definition of all the different points of similarity that could constitute infringement. So I think we could compartmentalize those two issues and deal with them separately.
Excellent point. Okay, we're a bit over time, but I think it was well worth it. At least it was well worth it for me. I enjoyed this so much. Thanks to all the panelists. Thanks to Judith for coming in and joining us. We're going to take a break now and then come back at noon for our keynote with Rosanne Cash. And so take a few minutes and then come back and join us at noon for Rosanne Cash. Thanks, everyone.
Thank you. Bye.